Good day, ladies and gentlemen. Welcome to Crim Law TV. Today we're going to discuss an article by Professor Colin Miller on the anchoring effect and why judges should be allowed to be part of plea negotiations.
The number you have reached, 911, has been changed to a non-published number.
Good day, ladies and gentlemen. Today's Crim Law TV is going to be about an article by Colin Miller, who is a professor at the John Marshall Law School in Chicago, and I believe is visiting at William & Mary this year. He had an article, it's up on SSRN, and he's kind of shopping around to see what people feel about it, and it's called Anchors Away, Why the Anchoring Effect Suggests Judges Should Be Able to Participate in Plea Discussions. And the article is about anchoring. And anchoring, for those of you who don't know, in a negotiation setting, the first person who sets out a stance, that stance, which is taken, is usually closer to where the final result will be than if the stance had started at a far lower end or far higher end. In other words, in plea negotiations in the United States, almost invariably the prosecutor has the first shot. And if the prosecutor says, I think your client should get 10 years, and then the odds are, even after some negotiations, that the final result is going to be 8 years or 9 years or something like that. Whereas if the defense attorney had been allowed to start the negotiations off, he might have said, well, look, my client probably deserves 2 years, and because of the anchoring effect, the final result might be 2, 3, 4 years, something like that, closer to what the defense attorney had offered. Now, the reality is, of course, that almost universally, the prosecutor will make the first offer. And therefore, his concern is that the offer will always be skewed higher than it probably should have been. And the offered solution to this is for judges to participate in plea negotiations. Now, there are two parts to this. First is, it assumes that judges will be neutral, that judges will, the prosecutor will always aim high, the defense attorney will always aim low, and that the judge will actually see through all the BS and find the actual range or the actual punishment that should be imposed, so that everybody knows what the reality is of what they're dealing with. The second is that, and he goes through a bunch of federal rules of evidence, etc., about the introduction of statements made during plea negotiations or pre-plea negotiations, etc., and he thinks that this will be the solution as to when plea negotiations start, because when the defense attorney, the prosecutor, and the defendant all walk into the court together to talk to the judge, plea negotiations start. Or, it could be part of the procedure that the judge actually has to say, here start the plea negotiations, something like that. I see problems with it. Now, I don't really have a huge problem with the judge taking part in plea negotiations, particularly in a situation, as he states, I think it's Connecticut, where the judge who takes part in the plea negotiations, it cannot be the judge who actually takes part in the trial. Okay? I don't have a huge problem with that, particularly if it's just kind of trying to hammer out the last year or two or whatever, where it's going to actually end up at. But I do see problems with it. First of all, I see the problems in the idea that judges are going to be neutral all the time. Well, everyone has biases, and judges are like everyone else. They have biases. There are going to be judges that are perceived as pro-defense attorney, and there are going to be judges that are perceived as pro-prosecution. In reality, probably more of them are going to be perceived as pro-prosecution, but there will be some sort of perception. Which means that when you go into negotiations and prosecutors going into Judge Smith who he knows will always lowball and always never believe anything the police say, etc., etc. He knows that if for a, you know, what he thinks should be 10 years and the defense attorney thinks should be 2 years, he knows that the judge is going to be at the 2 year part, and he's not really going to seriously partake in these negotiations. The same thing is going to happen a lot of times with defense attorneys. They know that Judge Jones is, an ex-prosecutor and always finds for police, and they expect that if the prosecutor wants 10 years and they want 2, that the judge is probably going to come down at about 9. So, they have a greater incentive to walk away from what the judge is saying as well and just go and take their trial, particularly if they get a brand new judge. Another problem is that anchoring really in, I think, most states is not anchored by the prosecution or anchored by the defense attorney. It's anchored by whatever the state legislature has set up as sentencing guidelines. Now, I don't know how many states have sentencing guidelines. I know we do in Virginia, and I know the federal system does. I know other states have them. I just don't know how they work in other states. And, you know, these guidelines, if the guidelines come down in Virginia, and the guidelines come down and say the sentence should be between 3 to 5 years, 4 years is the midpoint, and 4 years being the presumptive sentence, well then, you have a pretty good idea of where you're going to start out at, and it will have an anchoring effect on what the final sentence is. Even if there are charges that are knocked out, a lot of times as part of the negotiation, a prosecutor will knock out charges that he doesn't think will stick, and he'll knock out charges which will stick just as part of the negotiation process and insist on staying closer to the guidelines. Now, of course, the guidelines are somewhat manipulable by the prosecution, and he is right in saying that, if the prosecution wants to, it can stack charges, which is to put, 7 charges on the guy for one event because there are several different, variations on different laws that he's broken. For instance, the typical one in Virginia, and I've seen this done everywhere, is when somebody goes in with a check that doesn't belong to him, writes somebody else's name on it, hands it over to the cashier, and then gets $100. He has committed forging for writing somebody else's name. He's committed uttering for passing the check to the cashier, and he's committed larceny by taking the $100. And you will see charged many times, all 3 charges. And particularly, this can add up a lot if you've got somebody that's gone on a spree and has cashed 15 or 20 checks that aren't theirs. They can end up with 50 or 60 charges. As well, although I haven't seen this personally so much, but it can, and as he points out, the prosecution could start out by charging higher than it actually thinks is a valid charge. I know that people get overcharged. I don't know that I've ever seen, and I've been in a prosecutor's office for 4 years now, and look, there are always places where things are done incorrectly, but I don't remember having taken part in any conversation where the idea is, well, we think he's guilty of manslaughter, but let's charge him with murder so that we can get him to agree to manslaughter in a plea agreement. I've never seen that conversation, and and I doubt that it happens all that often. But it could somewhere. Now, your problem here is this. If what you're trying to get to with the judge taking part in the plea negotiations is to shake out the overcharges, whether they be from stacking charges or from overcharging the level of the offense, or if the defense attorney thinks that there's evidence that probably would be excluded if there was a trial, see, what you end up with is a mini trial. So the defense attorney and prosecutor get together with the judge, and the evidence is put on, and the judge, it's basically a mini trial, and so the judge says, well, it should get three years. You know, uh, 2 to 3 year range, 3 years midpoint. That's where I think it should be. Um, and he's already decided what he would have excluded, and he's decided if something's overcharged or there are too many charges, and so that's the first bite the defendant has at the apple. And if the defendant doesn't like that, he would obviously have the right to go forward and actually take his actual trial, uh, which is kind of problematic. The two bite at the apples bothers me. In some states, there's problems with this anchoring effect as well, in that even if it's not the right to go to trial in Virginia, say, the judge can't guarantee any kind of sentence because in Virginia, jury sentence. Now I realize this only happens in 4 states, but in a state where juries sentence, a judge saying, "Well, I think this should end up about 3 years," is not really pertinent. It really doesn't accomplish anything because, well, the jury is going to decide how much time a person should get, and the judge can't guarantee that, or should not be able to. The final problem I see with this is that I think there would be a very wide difference in implementation. There'd be Pitcairn County, which has 10,000 citizens, um, one prosecutor, one judge, and say 4 attorneys that come to the county, and for their 6 cases that month, the judge can take everybody back in his chambers. They can spend 2 hours going over every last detail. They can figure it all out, and then the judge could go, well, yes, and this is a 4 to 6 year sentence, with 5 years being about the middle point, probably where I'd sentence somebody. Okay, very in depth, very worked out. Let's assume the judge is neutral in the whole 9 yards. And that could work, or it could mean the judge meddles far too much into the case. Um, on the other hand, you know, what if you're in the city of Chicago, New York, D.C., or even someplace like Richmond, and um, you've got hundreds of people coming through every day. You know, uh, your judge doesn't have time to have that nice, slow, let's talk it out thing in the back room in his office, in chambers. So I think what you end up with then is, you know, hearing where there's 30 people sitting in the courtroom. You got the prosecutor sitting there, and you got the defense attorney sitting there. Uh, you know, Adam, Ann Adams is called up, and the judge goes, "Okay, prosecutor, what's your offer on this?" The prosecutor says, "7 years, judge." Defense attorney, what do you think is valid on this? 3 years, judge. Okay, Mr. Prosecutor, give me 2 minutes as to why it should be 7 years. Well, she beat on this guy, and she stole his money, blah, 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 all the terrible things she did. Defense attorney, why do you think it should be? You got 5 minutes. Tell me why you think this should not be. Well, you know, she's a mom, she's got kids, she's never been arrested before, blah, 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 it goes on. And then the judge, kind of just randomly picks a number out of the air, even if he may not even give them 5 minutes apiece. It may be something where if the docket's that heavy, where he's giving them 2 minutes apiece or 1 minute apiece. Just boom, 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 getting it done, and no serious review. Well, ladies and gentlemen, that's my thoughts for this today. I will put a link up at crimlaw.blogspot.com, which will tell you where to go to see this article. And if I can figure out how to do it, I'll do it on YouTube as well, on my Crim Law channel. But that's it for this week. Next week, we'll see what we see then. Y'all have a good week now.